Welcome.
Thank you. I was hiding from you off the side. Hey, thank you very much for letting me come speak with you today. I'm excited about doing this. It's a topic that I'm pretty passionate about, that I've spent the last 30 years of my career really in the public sector. I started off as a police officer many years ago, moved into private industry. If I can find a way to move this thing forward. I moved into the private industry and worked for a couple large companies, but still focused on the public sector space. And so I've been doing this for a long time. My last 20 years has been at Tyler. I've been running the professional services organization there, where I've been implementing our software across the US. And I've been part of most of our major implementations for the court systems themselves. So that's been kind of a fun thing for me to do. This last couple of years, I've been really focused on what we call our enterprise supervision product, which is really around supervision. And that's been a lot of fun for me. I've enjoyed that. It's an area that I've been passionate about for a long time. So let's get into what are we going to talk about today? There's a couple things we're going to talk about, but really this is a focus on technology around this space. There is a lot of different technology that's come out. There's a lot of new things that can be done. But to look at that, I kind of want to look back and kind of level set kind of where we're at, where we came from a little bit in this space too. Bail reform, pretrial services, we'll examine that technology in its entirety to some degree. Traditionally, bail reform systems require defendants to pay a certain amount, really to guarantee that security that I'm going to come back to court, right? And that historically has shown that it's been criticized because it's not been successful, really. It's all based on the outcome, and it's perpetuated inequality within that area, which is kind of an issue. The majority of defendants statistically actually do show up for court, and they actually do what they need to do. They finish those things appropriately. But we could do better, right? So history, there's really three waves that this has went through for bail reform. One of those, that first wave was back in 1964. It was coincided with the civil rights movement. And then the next wave really was through the 70s and 80s, and I remember this really well. I was actually a young teenager at that time when we went through the period of time that talked about all the hard times on drugs, right? We were real tough on drugs at the time, the war on crime, so to speak. And then the last wave is the wave we're in today, that third wave. And it's really came a long way in the last few years. The last 10 years, though, has been critical. It's been a major change in this area. When I start to examine the data in this area, and this is what's interesting to me, when I look at the criminal jail data, this is local jurisdictions within jails across the US, I see that there's about 620,000 people that are incarcerated in those local jails, but only 427,000 of them haven't went to trial yet. They're still in that pretrial stage. That's a large number. When I dig a little deeper into the data itself, what I see is a pretty big disparity from the growth of the justice system and how we've incarcerated people in those jails, and the difference from who's in jail and out of jail that's been convicted or not convicted. If I look a little deeper into that, what you'll see is in the last 34 years, the convicted is up about 100%. That's a pretty big growth in convicted people that are in jail. But the non-convicted is up 300%. It's clearly outpaced everything else, which means our bail reform and pretrial systems are a little bit being taxed at this point. So where does that take us, right? Bail reform advocates for alternative approaches, and that's been going on for some time. It really looks at prioritizing public safety, the presumption of innocence, looking at those individuals, and to reduce that unnecessary pretrial detention. The financial and social considerations are also drivers for bail reform as well, right? So ultimately, our goal here is to create a system that promotes fairness, reduces unnecessary detention, and ensures the individuals are not incarcerated simply because they just can't pay. They don't have the money to pay or the means to pay. By implementing evidence-based practices, risk assessments, and individualized decision-making, bail reform seeks to strike that balance between safety and the rights of the accused. Pretrial services, which brings me to this, right? There's a lot to do with pretrial services here, and that area has grown tremendously. When I look at pretrial, the pretrial service from my perspective, the pretrial service refer to programs and services that are designed to assist the court in making those decisions regarding the release and detention of individuals who have been accused of a crime but have not yet gone to trial, right? So, what do pretrial services include? Well, there's a little bit here, right? The specific nature and availability of pretrial services may vary across jurisdictions as different regions have different assets available to them. They have different policies within those jurisdictions. So it's gonna vary. There's not one answer for everything across the US. But there is some commonalities that we can all come back to. So the goal of pretrial, from my perspective again, really is all about thriving. The primary goal of pretrial services is to ensure the court's consideration of releasing defendants before they're diverting from traditional prosecution steps. That's the first part. The second really is around these services aim to strike a balance between protecting the community and respecting the rights of that individual that's being accused, but it has not gone to trial yet. So if that's our goal that we're trying to achieve, and we're really trying to also reduce recidivism within that area, what does that do for us? A consideration for a robust pretrial system has a bunch of different programs to it. It has a lot of elements. We'll talk a little bit about those elements and then how technology can apply to some of those elements, right? So the considerations for true trial, if we're establishing a collaborative pretrial system mapping across our organization, right, our jurisdiction, so that we know how we're gonna handle all those folks from start to finish. So I love this conference and this group because that's what these people come together, it's what you come together and do. We also want to increase the use of citation summons. We see this across the US, but more of that could be used. An example from my perspective is Texas. In Texas right now, you can get pulled over for marijuana, softer marijuana, you get ran into, it's a citation, oftentimes, not always an arrest. It depends on how much you have and what's going on, but there's a good value in thinking about it that way. It's still illegal, but do I really have to go to jail? Can I divert from that traditional process? So regular review of a total pretrial jail population. This is one thing that I'm passionate about personally. I do believe that the population that's in jail, so if I review you when you first get arrested and I assess what your conditions are, can I release you or not, but yet I don't go back and look at you 30, 45 days later and your conditions have changed, then I'm doing you a disservice. So it's a constant review of that population to go, hey, are you now releasable? Has something changed that makes you releasable? The charge could be reduced. There are several things that could happen that could make you releasable at that time. So it's important to do that. And then conduct meaningful first appearances, right? Making sure the attorney's present and available to you, and you've had, that review has been done, the assessment's been done and completed. Because if we didn't get that work done, that first appearance isn't as valuable as it could have been. So, reducing recidivism or likelihood of individuals reoffending is a crucial goal of the pretrial system. While there is no one-size-fits-all approach, several strategies have shown promise in reducing this recidivism, right? Let's talk about a couple of those. The risk assessment. Now, I don't love the word risk. I wish it was just called assessment, but that's the general term that's being used. To some degree, there is risk, but it's really assessment of what your conditions are. It really is looking at that individual in a robust way. So if we utilize evidence-based risk assessment tools to identify defendants' risk levels accurately, these tools consider factors such as criminal history, offense severity, substance abuse, employment status, and it used to do a lot of community ties. But we've learned over the data now is telling us that actually a lot of the community ties don't matter as much. It doesn't have much involvement. But by identifying the higher risk individuals and appropriate supervision interventions can be tailored to their needs. And that's the important part there, is tailoring those assessments to the needs of the person that you're assessing. Another one that it's really valuable is the tailor release conditions to address specific risk factors and needs identified through that risk assessment process. This is so that that individual can have the conditions that they need to do better, right? If we tailor it to that individual and not just a one-size-fits-all philosophy, then that individual can have a better chance at post-trial in the end. Pretrial services and support. So conduct regular check-ins, monitor and support for defendants released before trial. The more we check in and monitor them, we know through data that they're more likely to show up for court, they're more likely to have a better outcome post-trial. And then access to service and support. So if we ensure defendants have access to necessary services and those resources, and we can address the underlying the factors that created the criminal behavior in the first place and address some of those through this process, this may include things like substance abuse treatment. It could be mental health counseling. It could be job training or housing in some cases. If we address those things through this process, we address some of the underlying challenges that we have with those individuals. The other area is collaboration with community organizations. This is key. The more collaboration we have with the community at large and the organizations within that community, and the more involvement they have in this process, the data shows that there's a better chance that the outcome is going to be positive at the end. So bringing those organizations in and making them part of this process is important. And then ongoing assessment and program evaluation. This is really important. Like I mentioned a minute ago, you have all these 427,000 people in jail. If I assess them only once, then I'm only going to get one view of that person. But their conditions change over time. I've got to reassess, and I've got to reassess because their conditions change as they are in jail. And our goal would be to get them out because they're just accused at this point. They're not convicted at this point. And it is way outpaced, right? We want good evidence-based decision-making and continuous improvement here. As we learn, adapt, adjust this process. And then automated court hearing appointment reminders. Through data, we now know that the more I remind you, even, I don't know, who in here has got a doctor's office or a dentist appointment and you get the little text messages that says, hey, you got an appointment on Tuesday. Reply yes if you still are gonna go, right? That's what we're talking about. Those reminders are really valuable. Data has shown that that actually impacts the ability to show up for court. It impacts the ability to connect and to work with pretrial services. The more of that we do, the more valuable it is. They actually work. So it's important to note that successful recidivism reduction requires a multifaceted approach. It's involving collaboration between justice agencies, service providers, and the community. By addressing the unique needs and risks of defendants and providing appropriate support, pretrial services can contribute to reducing that recidivism rates and promoting positive outcomes for individuals involved in the criminal justice system. Well, how does technology play a role in all of these pieces? So let's talk about that a little bit. Let me back up. I'm going to introduce Andy Kahn. He's going to come up here and talk for just a second. Andy is an advocate for victims' rights. And it's an interesting point of view he has. So it was interesting for me to listen to him.
Is Andy Kahn. I'm the Director of Victim Services for Crime Stoppers of Houston. I've been a victim advocate now for over 30 years. Prior to that, I was actually a parole and probation agent. And then I started work as the country's first victim advocate to ever be staffed out of a mayor's office in 1992. When I worked in the criminal justice system for years and I saw stuff that literally, left me, my eyes dropped and jaws dropped just because I saw so many people that were being victims that frankly never should have been victims, and they were victimized by the system. And I just decided, it was time to let everybody know what was really going on. Crime victims are the only unwilling participants in the criminal justice system. Everyone else chose their role. Law enforcement, judges, prosecutors, defense attorneys, and obviously the defendant. but no one ever said, pick me, I want to be a victim of a crime. So the least we can do, particularly in government, is to be looking out for the victims' rights, their due process, and their well-being. And that's kind of the mantra that I took on. So in 2019, we started noticing at Crime Stoppers a trend. And the trend that we started seeing was, particularly in the cases of homicide, we started noticing that a lot of defendants charged with murder had been repeatedly released from the courts on multiple felony bonds, or they were given what was called a PR, a personal recognizance bonds, which in street terms basically is a get out of jail free card. One of the issues that was brought up was that courts would say, well, we didn't know that this person, had all this prior criminal history. One of the other factors that came up as far as technology goes is the proverbial left hand doesn't know what the right hand is doing. And we found out that in a lot of cases, when a defendant was charged in one county, that county was not aware that they were on bond from another county. One of the things that we've noticed at Crime Stoppers is that, keep in mind, the majority of defendants are going to be released on bond, period. The question is, okay, now they're out on bond, the types of conditions that they're given. You put them on house arrest, but now how do you actually ensure that's going to be complied with? So the conditions are fine. It's the actual implementation of ensuring that the offender is in compliance and then taking swift action, not weeks, not months, but swift action if they're not in compliance. That's kind of the missing area right now. And I think that's where technology can play a much stronger role. And we routinely see reports submitted by Harris County Pretrial Services and the probation department that they can't get in touch with the defendant. And they list all these different dates. And then from our perspective, we're wondering, why is this taking so long for this information to get back to the court for them to make a decision on what to do? We've got to start looking at how to partner more with agencies like pretrial services that are given the task of monitoring defendants that are out on bail, and particularly from the GPS side, as to how much more quicker response time.
Brings up some interesting points. All right. It was interesting to listen to him talk and do that interview, because it's an outside perspective of the view of what's happening within the court systems. So it was interesting to me. But some of the interesting points he brings up is really how technology can solve some of the challenges and problems that they have. So technology does play a robust role in this. Let's dig into that a little bit. It's a basic thing, but having a digital case management system for pretrial services is important. It is extremely valuable, and there's some jurisdictions that still don't have one. They're still doing it on paper in some cases, or trying to use a product that's not designed for that exactly. So having that base case management system is a valuable asset for any jurisdiction, especially if that case management system can interface with the court systems, so that you do get rid of the duplicate entry and you have access to send data back and forth. There's a lot of value in that. Another area that is valuable, and again, I don't love the word risk assessment, but risk assessments themselves. Having a robust process for how you assess people initially, then how you assess them ongoing, is valuable. And you might use different tools for different times that you're doing those assessments. So technology can definitely assist you in that by implementing that and having a record of that and sending that over electronically. And there's various algorithms that are used in the industry that you can apply to these scenarios. In the end, you want to create that report and send it over to the court so they have access and see what you're looking at from a pretrial services standpoint. Next, that's system alerts. Having a system that has alerts and can send alerts to both the officer or the supervisor or anyone in the system when timeframes need to be met or reminders need to happen, that's extremely valuable. And it's sometimes very overlooked in the case management system itself. So using that system alerts and reminders has proven to work with officers and supervisors to make sure they get the things done when they need to get them done. They're busy. There's a lot going on. The other thing that we have seen within the industry is swarm on reminders. This idea of swarm on reminders is really about the text messaging and the phone calls. You can set up automation that text messages someone that says, hey, are you gonna show for court next Tuesday? Your appointment's at 9 a.m. Or, hey, you gotta go to do a drug testing Thursday at 3. Are you gonna be there Thursday at 3? And you remind them until they respond to you. You can even set it up to automatically call them and remind them. You get a phone call till you get an answer, right? So those swarming on reminders is extremely valuable for the offender themselves, the accused that's out on pretrial release. And it's also good for the officers because they can see if they responded or not. Have they received it? Have they read it? What's the status of that reminder? The other option for higher risk individuals is really around electronic monitoring of that individual. Setting up those zones, being able to see where they're at, where they can go, where they shouldn't go, if any conditions exist like that. In this example, in this picture here, what we're referring to here is he's taken a interlock device within a car that doesn't let his car start. That's one option that you can apply. You could also apply remote breath to someone. I like the remote breath idea because remote breath lets you take a video and a picture of the person, does facial recognition to make sure that, hey, Kid Miles that can't be drinking alcohol actually was a person that blew into this. I've had stories of individuals that in these interlock devices in cars literally have their daughter blow into it, their 6-year-old daughter blow into it so they can start the car and drive. Scary as that sounds, that actually is happening, right? So I like the other one better, but anytime we're doing remote monitoring, I think there's a lot of value in it. This was the remote vet I was talking about a minute ago, where it does take video and it captures you, it does facial recognition. I think there's a lot of value in that too. And then for GPS monitoring itself, there's a lot of options for the level of security you want to apply to the individual. How often does that GPS track them? How does it interface with the software itself? What kind of strap do you use on that individual? Is it a high density strap that can't cut, or is it a lower one that could be cut, but they're a low offender and it's easier? Longer battery life oftentimes are options as well. So there's a lot of options with electronic monitoring that are out there today. I would encourage you to think about your technology here. If your case management system can interact with all the electronic monitoring itself, and it's device agnostic, and you can have multiple devices in the field and being used at one time, there's a lot of value in that. It's better for the officers, it's less time entry for the folks that are managing this. And if you have to change from one device to another because conditions have changed for that individual, because it's device agnostic, there's value in that, less work for you to do. Mobile apps, remote monitoring and supervision. In general, remote monitoring can help reduce the costs associated with traditional supervision methods while providing that oversight and accountability. Kind of wrap that remote monitoring up. Mobile apps, I really like them a lot. I think there's a lot of advancements here that we can do. There are some great apps out on the market already. There's a lot out there. But if you have a mobile app that's very integrated with their CMS that allows you to communicate back and forth, it's a pretty awesome connection. Stay connected via mobile apps. That's for officers and the individuals. The officer has an app. The individual has an app they can use. They can see their conditions. They can see when their appointments are. You can do secure communications back and forth with those mobile apps. Mobile check-ins is another area that's valuable. If you have mobile check-ins, they don't have to come to the office. They can just check in remotely. There's a lot of value in that too. There's call centers. There's technology today. You can call up and use voice recognition to make sure that's actually the person calling in and answering the questions. So there's a lot of value in that as well. So communication and collaboration. Having the ability to secure communications to interact with a person that's on supervision, being able to share documents back and forth, verify they're talking to the right person because of facial recognition through that app. There's a lot of value in those apps that are pretty robust today. That wasn't around 5 years ago. These are a lot of different technology that's available today. And then getting into predictive analytics and early intervention. When I think about how to use the apps differently, what comes to mind from my perspective when I say predictive analytics? It's really about helping that person connect to those local services. If I'm an individual that's struggling with substance abuse, the traditional thought was, hey, I want to violate you as quickly as I can and put you back in jail. That's no longer the thought anymore. The thought is trying to help those individuals. And we know through data that tells us the more I connect them with local services, the more I get them to underlying problems and deal with those underlying problems, the more likely they are to not reoffend, the more likely they are to have a better outcome post-trial. So instead of, through communication, asking someone, did you drink today? Think about changing that a little bit. Are you struggling with alcohol or substance abuse? If you are, and you answer yes to that question via the app, can I provide a connection to you to how to get help for substance abuse? Can I alert the officer and let them know that, hey, you're struggling with substance abuse right now. Let's get this person some help. So there's a value in how we can communicate if we change that script a little bit from our traditional thought process. Data. All of this collects data. The more data you collect, obviously, the more you understand about the outcome within your jurisdiction. But having access to really read that data, analyze that data, understand what it's telling you for your jurisdiction and how you need to then adjust what's going on, there's a lot of value in that. So technology enables that collection of storage and analysis of vast amounts of data related to defendants. Their backgrounds, the interactions, the criminal justice system. By using that data analytics, pretrial services can identify patterns, trends, and risk factors associated with the recidivism, and they can then inform an evidence-based practices to guide that decision-making and lending a more effective supervision strategies to support programs. All that being said is, having a dashboard that you can look at the data that's happening and be able to read that data in an effective way is going to let you make better decisions across your court. Better decisions across how to adjust your pretrial services program. And this is one of my own, I think about the way I think about measuring what matters, when I think about those pieces, I think about it in a different way. Language begins to matter in some cases. And it's not just me. There's a standard that's out there, and it talks about this. Performance measures should use positive language, wording that reflects goals and values to your local pretrial system, and encourages community confidence in the local criminal legal system. For example, court appearance rate is a positive phrased way to report progress towards a major pretrial goal, right? Another way to say it is your failure to appear rate, but that's a negative. So using those positives in language in the reporting, even the words on the screen, even the words on those reports start to matter. People will start to regurgitate it that way. They'll use it that way. The clerks do. The officers will. So that's why I think language matters in this area. The NCIC measurements all matter. I'm not going to get into all the details of each of the measurements, but there's a lot of them out there. There's a lot of good insight available to you in that way. So, technology. It should augment the decision-making process and support the goals of pretrial services, rather than replace that crucial role of professional in the field. It's augmenting that professional in the field. However, while technology can be a valuable tool, it should always be used in conjunction with human judgment. We've got to make some of those decisions. We can't let the system make those decisions for us. It can direct us, it can advise us, but let's make those decisions. So are we accomplishing those goals that I talked about earlier? If we were to get into that, I think you got to ask yourself a few questions. You got to ask yourself, are we working towards the correct goals? Are we aligned? Are we investing in a program? Because if we're not investing in that program, spending time in it, putting money on it, then it's going to die. We know that we don't focus on things, those things don't grow. Are we adapting as we learn? We're going to constantly learn through this process and this program. We've got to adapt as time goes on. So I'm going to leave you with some links to some systems. You probably already have all these, but there's a lot of good value in the links that are here. I'll also leave you some links to some of the technology that I referenced that you can have. But what I want to leave you with is kind of a special thanks from me to you. Thank you for your dedication and service to the justice system, all of you in here. Let us move forward with a shared commitment to bail reform, to a robust pretrial system for all of us, work towards a brighter and more just tomorrow. Thank you for your time today. I appreciate everybody. It was great to be up here.